Evan's gone on to do a lot of cool things. For a couple of years, he was representing startups in Silicon Valley at a big law firm out there. And now he's come back to get his hands dirty, doing some, working on some product here in New York. And I look forward to seeing what his next steps are also. He got his law degree here at NYU, NYU Law. And he teaches as an adjunct in the School of Media, Culture, and Communications. And if you like what you hear today, you could actually take his class next semester. He'll be teaching a class on this subject primarily.
Yeah, it's called Copyright, Commerce, and Culture, and it covers pretty much all the copyright you'd want to know if you care about culture and don't feel like going to law school.
And he's also got a great voice, as you just heard. So Evan,
that's nice of him. Thank you. Well, one thing I'll add to that is that, luckily, in some ways, I guess, I'm not a copyright lawyer. I am a lawyer. I studied copyright a lot in undergrad, and I teach it now at NYU, but I don't have a dog in this fight. I'm not here to tell you that I represent music companies and they're in terrible shape and they're going to die, and so you should help them. I'm also not here to tell you that I represent a maker of file sharing software and everything about copyright keeps it from being what it could be. I believe that, there's a lot of merit to both of those positions in their own way. But like I said, I'm not here to tell you the way copyright should be. I'm here to tell you some of the way copyright is and hopefully get you guys to think about maybe the way copyright should be under your own views and your own thinking. So the first thing that we have to start with, I'm sure this will be a review for some of you, but I do have to make sure we're talking about the same terms. Copyright is not intellectual property. When you say intellectual property, you're using a term of convenience that covers 4 entirely distinct areas of law that have some common grounding but don't operate in the same way at all. You cannot say just, that violates my intellectual property. That's not a very helpful statement. You need to tell me which kind of intellectual property it might violate. So the 3 main kinds are copyright, patent, trademark law, and trade secrets law is sometimes lumped in there, but unlike the other 3, there's no federal statute. It's just a creature of state statute, so it varies so much that it's very hard to talk about in a sort of overarching fashion in a short lecture like this one. So we won't be covering that at all. Copyright is based around the incentive to create. We have copyright because we want people to create more work. We like the fact that people produce creative output, and we think that as a society we should provide some incentive beyond the sort of baseline to get people to do that. But it only covers those works. It covers the expression of ideas, not ideas themselves. And all you really need to produce a copyrighted work is a napkin and a pen. I have here, I was thinking on the subway, probably don't even need that. You could probably find a way to sort of scrawl something in blood on the wall, and if it was good enough, it was original, it would be copyrighted. You do not need to register a copyright. This is a sort of common misconception. There's reasons why you might want to. It is required if you want to sue somebody over that copyright, but you can do it right before you file that lawsuit. So it's no longer required, and so you have your copyright from the minute you put pen to paper, napkin, or whatever. So what you get is a bundle of rights, which is true about a lot of legal concepts, but here what you get to do is control the copying, the performing, the distribution, and a few other things of that work that you just created with your napkin and your pen. You get to do that for your entire lifetime, plus 70 years, so well into your grandchildren's lifetime, and it is subject to defenses like independent, that should be creation, and fair use, as well as some statutory exceptions. So there are exceptions. You don't get to prevent any and all copying at any point for any reason, but it's a fairly strong right. It does keep you protected from people who would make other uses of your work that you wouldn't prefer. Patents differ in a few key ways. Patents are about the incentive to invent, which is a lot like the incentive to create, but they also involve the incentive to disclose. Unlike copyright, where we pretty much think that as soon as you've made a work, you've told us everything we need to know about it. You have written the book, we can read the book. Patents cover inventions where it's actually very important and interesting for us to get at how you built that invention. How does it work? So patents require you to not only invent the thing, but apply for a patent in which application you disclose how you made the thing, how this useful thing operates. Because patents are different and have this sort of prior examination process where you have to apply and get one, there's a few more requirements. You need to have patentable subject matter, which is a very broad category, but there are some things that don't fall into it. It has to be new, it has to be useful, and most importantly and most distinct from copyright, it has to not be obvious to FOSITA, which is a terrible acronym that stands for person having ordinary skill in the art, meaning not obvious to a layperson because, of course, almost nothing that we invent in this gilded modern age of ours is obvious to any random person on the street, but someone who's good at what you do, a reasonably skilled coder, should not think that this is a completely obvious extension of what actually exists right now. It has to be an advancement of the state of the art. So like I said, it's a system of prior examination. The PTO only gives you a patent after years of examination. It often costs on the order of millions of dollars to get a particularly sort of broad and powerful patent through the patent office. It takes years. This is why if you ever hear a lot of tech startups who have very interesting products, somebody in the audience will always ask them, how do you protect your intellectual property? Do you get patents on this stuff? Because this looks like some brand new stuff. And they say, no, we don't have the time, we don't have the effort. That would be a huge distraction for us. And it is, because it takes a lot of work and a lot of money to get it. But once you get it, you are pretty much in the money. You guys have probably heard of some pretty huge patent settlements in the last few years. I believe it was the RIM case governing BlackBerries, where they had to pay out over $600 million to settle a suit because they were afraid they were going to get hit with a judgment for a lot more if they actually went through with the whole case. Sorry?
So I hope I'm not confusing my terms, but
no.
Didn't Facebook recently patent places, even though it's something that they didn't really invent?
Yes, well, I mean, and this is a problem with patents and with copyrights, but more with patents because it requires that it be so new and non-obvious. So I believe Facebook did try to get, they may have filed for a patent. I don't know if they were awarded it. Like I said, that takes years, and the difference between, any of us could go fill out a patent application tomorrow and say, I have invented this awesome new thing. It's called, what's one of the most famous ones is the one-click to buy button from Amazon. I have invented this thing whereby I will store your credit card information and order you a thing when you click on a button. We can do that, but if it's actually been granted, then you get all of these exclusive rights. You get the exclusive right to make, sell, or use for 20 years from issuance. And this is one thing that we should note about issuance is that we are sort of unique in the world in being a first-to-file jurisdiction. Sorry, we are first to invent. Everyone else is first to file. You can tell I'm a copyright professor, not a patent professor. But the interesting thing about that is that there is this sort of, everywhere else, there's this sort of race to the office. Who can file that application first? Because then you get it. Because, like anybody you guys have all probably thought about this at one point. It seems like people invent good things all at the same time. There's a lot of reasons to think that at any given moment we are getting these inventions, and they're coming out of some mass development whereby lots of different people are at the point where they could make that invention. And so we say, but we decide to care about who's the first to invent. And so you get a lot of fights about that. It's called priority in the patent office, where you wonder back and forth about who invented it first, who really came up with the important part of the invention before the other person, and that can actually eat up a lot of the time in the patent application process too. So that's why 20 years from issuance is, might take a little longer than you think because of all these things lengthening the term of the application process. And it's also worth noting that you don't get to say, like you would under copyright, oh, well, I didn't have any access to that person's invention. There's no independent invention defense. You can't say, oh, I came up with it, and I've never heard of this other guy who already has a patent. that's not a defense. You will be, if you are infringing on that patent, you can be stopped from doing it no matter how you came up with it. And similarly, there's no fair use. You don't get to say, oh man, but I'm doing something socially valuable with this patent, or I'm somehow providing a critique of this patent through my practicing of it. That just isn't part of the law. So copyrights and patents often get pushed together because they seem to cover, there are things like software where they could cover, it could be covered by both areas of law. So here I think I just want to emphasize a few ways in which I think it's important to draw a distinction. We are protecting them for different reasons. I think it's really hard to square the protection of expression in the one case and sort of providing an encouragement for people to make more creative works with the incentive to invent, where you want people to make something that's new and useful. Whereas if we probably don't want to require every book be somehow useful, or even have this requirement that it not be obvious. We think that's generally, I think, too much of a burden to place on creativity. We don't want the law to be that judgmental about whether or not creative works are any good, but we're more comfortable with it when we have the notion that it's an invention, it's supposed to be useful, it's there to advance the state of the art. And I have this last point, free speech interests being different, because I think it's an open question. I think there's obviously free speech interests in people creating expressive works. I think, you know, that almost goes without saying. But I think there's probably some free speech interests in the process of invention. And I think they get short shrift when we talk about these issues. Copyright is often balanced in the First Amendment context. People often think about it that way. You don't see much talk about how patents might be infringing on people's First Amendment interests. So that's an open question worth considering. Trademarks are the last piece of intellectual property. They are very different in the way that they're handled and in what they're designed to protect. They are protecting source identifiers, mostly brands. So what you need is something on your product that identifies where it came from. And this can be a lot of different things. It can be basically whatever people have come to associate with your product. It's a little bit circular, but that's how it ends up working. Anything you do to get people to understand that a product comes from you can probably be protected as a trademark if you're successful in that effort. If people do identify that thing, that sound, picture, word, whatever, with your product. So what you get when you have a trademark is the right to prevent consumer confusion. So when you talk about trademark infringement, you're talking about the process of going in there and proving to the court that the average consumer, sort of often thought of as the average guy in a mall, they actually do mall surveys in these cases, would he think that this infringing product is actually yours? Is the color too close? Is the wording too close? Going back to Facebook for a second, there was a startup, there still is a startup, which eventually had to change its name, called Placebook, that Facebook decided sounded a little too similar. It didn't really necessarily have anything to do with Facebook. I believe it was more of a sort of, well, but it was a geolocation startup. Facebook has a dog in that race now. They were obviously worried about it. And rather than take it to court, the small startup just said, okay, fine, we'll pick a different name. But that's basically what they're going for, is they're saying that if I saw Placebook, I might think it was Facebook's Places feature or something like that. So trademarks, though, don't have a term. As long as you're out there selling the good under this brand, you get to keep doing that, and you get to keep keeping people from confusing your consumers. But it is subject to a different kind of fair use. It has fair use exceptions all its own, which are much more focused on the First Amendment interest because it is very much more directly about controlling the use of language. So if I were to try and get a copyright on a couple of words, it would probably be too short. It probably wouldn't be original. There are a number of reasons why, you know, a lot of this comes around copyrighting titles and stuff like that. Copyright generally protects longer works. But trademarks, I mean, the entire point is to protect a brand that's often very short, often very pithy, often something that we already have used, like, say, Facebook. I mean, that word was in common usage before the website existed. And so you have a very strong First Amendment concern regarding what you let people say. I mean, what you find yourself allowed to talk about without being subject to the threat of a lawsuit. So that's trademarks. Now we're going to talk about why we end up calling it intellectual property. Why do all these things, different though they are, end up under the same label? And basically, it's because we treat it like property. You have to excuse the formatting there. This thing has been through Google Docs, into Keynote, back to PowerPoint. It's lucky you can read it at all, probably. But the property-esque interest here is that we have that fundamental right to exclude others. That's basically what property is about, is I get to say, this is mine, and you can't use it unless I tell you you can. And I have the right to transfer that. So I have the right to say, you can pay me, and then you can not only come on my property or do what you will with my property, but you can actually own it and give that right out to other people. So in that way, it feels like property, and that's the sort of intuition that leads us to call it intellectual property. But it's really not. And this is a quote from Thomas Jefferson that I think really encapsulates why it's not quite the same thing. So hopefully all of you can read that, but I'll read it. Its peculiar character, too, is that no one possesses the less because every other possesses the whole of it. He who receives an idea from me receives instruction himself without lessening mine, as he who lights his taper at mine receives light without darkening me. Now, this is a very eloquent exposition of a concept that they have a term for in economics. Anybody know what I'm talking about in economics, taking the course? Okay. It's called rivalry. And what Thomas Jefferson is talking about is the concept of rivalrous and non-rivalrous goods. And what that means is to say that there are goods that your use or enjoyment of prevents others from using or enjoying that good. Basically, you know, I'm drinking this bottle of water. Once I'm done with it, no one gets to drink this water. And sanitation, whatever aside, you know, once I have this laptop, I'm using it, nobody else gets to use it, it's mine. Were someone else to take it away and start typing on it, I wouldn't have the use of it anymore. Non-rivalrous goods don't have that feature. They are, like it says here in some of these examples, things that we enjoy without excluding others from. So common ones are sort of thought of as national defense, broadcast TV, and most of what we consider to be intellectual property. It doesn't take anything away from you, sort of in terms of actual physical properties of things, for me to know an idea that you already know. It's basically the issue there. Now, this matrix describes also this aspect of excludable versus non-excludable, which is to say, can you keep other people from using this good while you're using it? And the important part of this matrix is really where the arrow is, because what we're talking about is intellectual property, which falls basically under the definition of a public good. It is the idea or expression or, you know, invention is not something that I can naturally exclude people from or something that naturally my use interferes with your use of. The problem with public goods, most economists will tell you, is that it's very hard to get a private market to provide for them because you can't exclude. You can't keep free riders out of the equation. They're going to come in and they're going to use up all your broadcast TV, all your national defense, all of those things. And so what intellectual property really does is sort of attempts to move things along that arrow. It attempts to take public goods and turn them into what they call club goods, which, if non-rivalrous, are at least excludable. They're at least something that we can charge for and therefore provide a, well, in the sort of romantic notion, a living to the struggling artist who needs to put food on the table and has to sell his novel, play, song to do that. So that's really the notion of rivalry and why rivalry is at the core of what we think of in terms of property. Intellectual property, right? Sorry. So on to some ancient thoughts about copyright. Again, apologies for the formatting. But this is not a new thing. We haven't had copyright in the law for a very long time, but it has been something that people have thought about as long as there have been books, basically. So back in the 560s, to every cow her calf, and to every book its copy, which is sort of an interesting framing of the question. You can think about whether you really wanted to take, you would really want to take parental rights seriously in this context. It's not too crazy. A lot of authors talk about their works as their children. They feel very connected to them. They feel very worried about, you know, how they're perceived and how they do out there in the world. The Roman poet Martial called plagiarism kidnapping. And in fact, the Latin root of the word is very much that. That's where we get plagiarism from. And you can think about it even in terms of, you know, you have a term of intellectual property protection. And afterwards, your invention, your work is free to go out there in the world on its own, make bad decisions, nothing you can do about it. It sort of turns 18 and gets out of the house. But it's also, there are sort of downsides to thinking about it that way. There are lots of things where we defer to a parent's judgment that we wouldn't necessarily want authors to control. You know, there are all sorts of parts of the law that allow parents to control their children's lives in ways that if we let authors do that with their works, we would be sort of left without very many works to consume. We wouldn't have libraries, we wouldn't have all sorts of things that rely on modulating an author's control over their work. You can see we also had a very common practice in the early development of copyright was to have these individual rights awarded, like Venice did in the 1460s, where you basically went to the ruling authority, you king or the duke of your city or whatever, and asked him for basically a specific statute that said your work was protected. It's almost like patents. It's almost like a system of prior examination. You'd go in there and you'd say, here's my book. Isn't it great? And the king would sort of sit there, read the book, and decide, okay, yeah, this deserves a term of protection. And that could vary from 5 years to forever. There were some that were perpetual. You know, this book is so great and so wonderful that your heirs and assigns forever and ever on into the end of time will continue to profit from it. Things like that were great for the people who wrote the great books, but it's very hard to structure an incentive system around that. You don't know if anyone's going to like your book. And so if you have to rely on this idea that, okay, well, you know, maybe someday I'll get even the barest protection from it based on an individual application to the king, that's not a right that is actually going to provide much of an incentive. It's not going to run a system like we'd like to have. I have to mention Albrecht Dürer's widow, who got one of the first copyright injunctions against an unauthorized engraving back in 1532. And it is, in fact, the best copyright notice ever, and I'll read it for you. Hold, you crafty ones, strangers to work and pilferers of other men's brains. Think not rashly to lay your thievish hands upon my works. Beware! Know you not that I have a grant from the most glorious Emperor Maximilian that not one throughout the imperial dominion shall be allowed to print or sell fictitious imitations of these engravings? I mean, that's a lot more forceful than just, you know, copyright, 1970, whatever. He really took it seriously. I don't think he ever actually got to damn anybody's immortal soul or anything as a result, but he cared a lot about this. You can see. There's also there were sometimes sort of religious implications. So the first Hebrew music printer in Venice was protected by a religious decree, not an action of the state in Venice, but rather a council of sort of the Jewish theological authority there, who said that, you know, any copying of this music that he had written down would be punished with the curse of the serpent's bite, whatever that ends up being. So those are early thoughts on copyright before we really get a system. But the system comes along in England with the Statute of Anne. They had a similar system, as we talked about, where people ended up making particular applications for patents. Basically, they called them all patents back then, where you would get a term, whatever it'll be, because you applied specifically to the authority. But they did eventually work around to a system where they had an open platform for you to come in and register your works. So they did have bans on importation, which is an interesting point because they were only really doing it. There's very little historical authority to support any other viewpoint other than that they were using it to censor Martin Luther. They were using it to keep his works from getting into the country. Now, they didn't have a First Amendment. They still don't. But it's definitely the kind of concern that we should always be worried about in America with the Constitution we have. You then had the Privy Council, which required pre-approval of new works. So you had to go and basically apply to be allowed to publish something, which again is sort of odious to our notions of the First Amendment. In 1662, you have the Printing Act, where everything has to be recorded, which is a registration system, and that starts to feel like a system that we had in this country for a long time. Registration did used to be very important in terms of getting copyright protection. But in 1710, you have the Statute of Anne, which is the first real copyright law that looks anything like the kind of protections we have today. So the limiting term was set to 14 years, renewable once for another 14. You did have to register and print notice on every copy that this was protected by copyright. And interestingly, it did give those rights to the authors. Previously, all the rights had been with publishers. Publishers would go and buy manuscripts from authors, right? Authors are the source of written works. But the author's only chance at any kind of money was that first payment from the publisher. The publisher would basically buy the work from the author, and that would be it. And there was no rights transferred there. That was just their real protection was in guarding that manuscript very closely. They had to keep it under lock and key or keep it hidden or whatever, because the physical manuscript was the only way that they could protect the publishers from just basically taking their ideas. So the Statute of Anne gives them some rights, but then you get caught in this unfortunate catch-22 for, you can see, from 1710 to 1774, where the Statute of Anne is out there saying you get 14 plus 14, so after 28 years, you really ought to be done, and I ought to be able to publish whatever I want without asking anybody. But they had this notion of a common law copyright. Basically, common law being judge-made law that sort of develops out there from opinions, isn't written down in a statute, but judges sort of just cite back to previous opinions saying this opinion is consistent with this common law notion of, in this case, copyright protection. So this case, Donaldson was the first to hold that, no, you can't actually have those two systems going at the same time, because then the Statute of Anne is a dead letter. It doesn't mean anything to say that you have 28 years of protection and then you have common law protection forever. That's a fairly useless way to construct a regime. So they said, you only have one bite at the apple. We're only going to give you those two 14-year terms. And that is very important because that creates the public domain. Without that, with a perpetual common law copyright, there is no such thing as a public domain. You always have to ask somebody's permission.
What's the public domain?
The public domain is everything that isn't covered by copyright. Good point. So in the colonies, there's not much book printing. You have a few American authors, but they mostly send all of their work to Britain to be published because that's where the market is. But you'll notice after some time, the U.S. shifts into a mode of both consuming and producing this creative work, and they start being concerned about protection. And you can see this in a number of countries today, where they're primarily consumers of intellectual property, and yet as their native production systems ramp up and they require some international popularity, then they start to worry about intellectual property protections. So some of it is certainly the U.S. dragging countries into the WTO and making them comply with, or rather join, international copyright treaty obligations. But some of it is a sort of nascent desire as your country starts producing intellectual property that other people might pirate to start getting those protections. And you can see that with a number of countries. I mean, China's one of the more notable examples, but it is happening all over the world right now. In 1783, Connecticut passed the first general copyright statute in the colonies. It looked a lot like the Statute of Anne. Many different states followed suit very quickly, varying 14 to 21-year terms, but pretty much the same statutes. And in 1788, as everyone was sitting around drafting the Constitution, trying to figure out what it was going to say, Jefferson and Madison were debating the utility of monopolies. They realized very early on that what we are talking about is a monopoly. We're talking about saying that you, the author, are the only person who can ever let anybody do anything with this creative work. And so it is a sort of miniature monopoly with all of the attendant economic consequences that you can see if, say, you are controlling all of the oil or all of the timber or all of any of the physical goods. And that's mostly because books aren't very good substitutes for each other. If you want to read one book, I can't just hand you a different book and make you happy, by and large. There are instances where, at the edges, maybe you would take that trade. But mostly, copyrighted works are unique. And therefore, you do have something of a monopoly control over the works that you have authored. Jefferson and Madison both saw good sides to this, but they didn't actually think that it was so terrible that we shouldn't have some kind of protection written in the Constitution. They understood that it's worth providing some incentive for authors to create, because if you give them those rights, they will be able, in theory, to, if not make a living, at least make enough off of a work to give them the incentive to provide more work. That's sort of the cycle that they're trying to enable there. So we end up with Article 1, Section 8, Clause 8, which is the part of the Constitution that lets us have a Copyright Act. So the basic constitutional theory, the federal government needs a power from somewhere in the Constitution to let it pass laws. This is actually a fairly specific one. Most of the modern regulatory state is based on the Commerce Clause, which is one sentence in the Constitution that says that Congress shall be able to regulate commerce among the several states. That gives us the Civil Rights Act, that gives us environmental protection, it gives us all sorts of things. Here we have a whole sentence in the Constitution, which isn't that long a document, just talking about copyrights and patents. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So here, actually, science is copyrighted material, and the useful arts are patentable subject matter. That's just how they talked about it back then. It's interesting to note that limited times is something that gets fought about a lot, and I'm sure you'll probably hear some of that in the next lecture from Fred about the Eldred case and some of the attempts at copyright reform that have happened in the past few years. But the basic premise there is that we are required to have a public domain, right? At some point, these copyrights and patents have to expire. We have to have some mass of unprotected work out there that we can draw from freely without worrying about the rights that we may be violating as a result of statutes that come out of this clause. Okay. So with this power, the first thing Congress does is pass the Copyright Act of 1790. Protects any map, charter, book, which is notable just because even from the very beginning, it wasn't just books. It was often thought about in books. I mean, Noah Webster was the person who really got this early copyright activism going, where he really wanted to protect his dictionary, which he had spent a lot of time working on. But even then, we had maps and charts involved. It was the same term as the Statute of Anne, you can see, 14 years, renewable for 14 more. Everything was vested in the author. Now we have what's called a work-for-hire doctrine, where if you do something for your employer in the scope of your employment, it's theirs, not yours. I mean, they're paying you to do it, basically. And formalities were required, meaning there were hoops you had to jump through to get a copyright. You did actually have to file a form. You did need to actually ask for this protection, basically. So one very important standard that comes up even in these very early cases, although we'll talk about a later case because it's the most recent law, is originality. So, as we mentioned before, copyright covers original, tangible works of authorship. It has to be somewhat original. So it can't be a fact. You can't copyright something that has this sort of independent existence and has always been out there. It's a fact about a thing. You may have discovered it. You may be the first person to know that fact, but you didn't make it up. You didn't come up with that. It existed before you found it. You do, however, have potential copyright protection for compilations. Basically, in the selection and arrangement of those facts, you can get copyright protection. And you can have invented facts. So there's a very interesting case about a guy who wrote a book that purported to be history, saying that Dillinger didn't die. Dillinger is still out there amongst us. He was never killed. And CBS went and made a TV show, an episode of some TV show that I don't think I ever watched, that basically used that plot, used a lot of details from the book. And he wanted to sue them for copyright infringement, and the court came back and said, no, basically, you're stopped from doing that. And estoppel is a legal doctrine that just says you can't benefit from something you have already sort of held to the contrary of. So you can't go in there and say, oh, wait, here's my historical book about Dillinger that contains well-researched facts, and I'm telling you he really didn't die, and come back into court and say, yeah, but here's my creative work about how Dillinger maybe didn't die that I want to sue you about. You have to pick one or the other. You either wrote a fact or you didn't. Similarly, we're not going to protect ideas. So we're only protecting particular expressions. Your idea may be original, that's true, but it isn't necessarily concrete enough for us to protect it. It's a little too dangerous for those sort of building blocks of our culture not to be allowed to be reused by other people. You can have your specific expression of it, and we'll protect that. But you can't necessarily say, oh, well, you know, I have a copyright on the idea of Dillinger not dying. That's too broad. It creates too many problems for both the First Amendment and for other creators who we want to provide incentives for. There is sort of a blurry line there, though, because you'll find out later that when you infringe a copyright, it can be on a basis of similarity, not identity, meaning you didn't just copy my book. You didn't just make a copy of my drawing or piece of music. Certainly, people get in trouble for doing that. That's definitely infringement. But you can also get in trouble for making something that's substantially similar to mine. If you basically, you know, change every other word, or if you change the colors in a picture, it's not the same picture anymore. But if it's substantially similar, if it seems that it is, for all intents and purposes, a copy, you can be liable for infringement. So there's a little bit of give in the notion of what's an idea and what's expression there, because you can get stuck with the idea that, oh, okay, well, you know, it's not the exact same expression. It's a different expression of the same idea, and you're still liable, even though in some, you know, you can make the argument that all you're doing is copying the idea. You get in trouble. Anyway, in 1991, the Supreme Court heard a case called Feist, which is about copying phone listings. And this is sort of the last word on originality, because this is one of the few times where a court has come down and said, listen, this is not original enough. There's no reason we need to give you a copyright in this, because you just haven't done anything new. And you can see what they basically said is that you need both independent creation, right? It does have to be new, you have to have made it, and minimal creativity. Some creative spark, no matter how crude, humble, or obvious it might be. And that's simply to say that it must have some tiny modicum of originality. And all we really know from this case, unfortunately, is that alphabetical lists aren't good enough. It's not interesting or new enough to alphabetize things. It may be interesting or new enough to put them in reverse alphabetical order. We don't know. But alphabetizing them straight is no good.
But isn't that a compilation of facts?
Yeah, it is a compilation of facts. And so the question is, did you do an original enough compilation to get copyright protection for that? So nobody's giving you copyright protection in the underlying phone numbers, although the defendants did make an argument saying that, you know, you didn't have the phone number until we created it for you, so maybe we created that fact. But in terms of the compilation, the question is it an original enough method of selection and arrangement to qualify for copyright protection?
I'm confused about how the case. So Feist copied an existing alphabetical listing of phone numbers.
Yes.
Did that listing have a copyright?
Well, that's what we're fighting about. Basically, the question is Rural's alphabetical phone listings, are those listings in their phone book copyrightable? Because if they're not copyrightable, then there's no infringement. I can copy them as much as I like. That's the basic principle at issue here. What's important is that the Supreme Court here, so this is binding on everybody in the United States, finally throws out what's called the sweat of the brow theory, which is something that had popped up over time, basically saying that, okay, this isn't original in any way, shape, or form, but you worked very hard at it. You put in a lot of time and effort to make this work, to put this book together. Maybe. And even though there's nothing new in it at all, everything is from somewhere else, and there's no originality in the selection that made it into a compilation, we're going to give you some rights here, because it would seem unfair for you to work this hard and have somebody come by and rip you off. And the court says, no, that's simply not how copyright works. That's not how the copyright clause structures our power to make these statutes. And so you don't get to have this sort of sweat of the brow theory. You basically are stuck with having some kind of originality. And what's interesting about this for today is that it precludes database rights, whereas the EU has what's called the Database Directive, where you can get rights in a database by simply saying, okay, here I have all of these facts that I've assembled in this database, and isn't this a good, big, thorough database, and don't you want to pay me money rather than just copying it from your friend who already has access? And what's interesting about this experiment is that this has been true for a while now. You can see the case was in 1991. And there's no real difference. We can't show any particular incentive effect in terms of the EU having more or better databases produced because they have these rights that we choose not to have. So it's one data point. It may change. It may be something that takes a long time to get going. But the fact is, right now I don't think we can say that those database rights have provided any necessary incentive, that there are other incentives at work. There's other reasons for you to do these things. You don't have to rely on copyright to get every intellectual product you might ever want to get produced. There are, other incentives at work as well. Sorry.
Back to the database thing. So the website Yelp has a large database of, they have both listings, which are just a collection of facts, which are potentially publicly available to anybody who collects them, and they have reviews, which I assume they own the reviews.
I don't know what their license says, but sure. I mean, either they own them or you own them.
If I would be able to write a script I want to create my own website with a lot of listings.
Right.
I want to compile it from scratch. Do you think it would?
Okay, well, here's where I tell you that while I am a lawyer, I'm not your lawyer, and so none of this is legal advice. I'm not telling you that you can go out and do that, but as an academic matter, I think there's a very good argument to say that what they've done in compiling those listings isn't inherently itself protectable. There's lots of copyrightable elements all over the website. We'll talk later about how their actual code is copyrightable, and lots of other things. So there's all sorts of ways to get in trouble. But in terms of copying those facts, I don't think they would have any particular right in the facts about the institutions themselves. The addresses, they are located in a certain place. I don't see why Yelp would either have a copyright, certainly not a copyright in those facts, and hard to see why they would have a copyright in the compilation of those facts, because that's simply saying, I provided a database of every vendor I know that is located within the city of New York. That feels a lot like alphabetical listings to me. That's just, it's not original, it's simply sort of dictated by the way things work.
I know you trained me well, because he was actually asking that for a startup video.
Yeah, well, I'm not trying to get sued up here. So the other point where originality came up sort of a long time ago and is still talked about a lot today is in photographs. So photographs weren't really contemplated, they weren't really something we could do when we first wrote the Copyright Act, when we first sort of wrote that power into the Constitution and all of that. But in 1884, forget who's the defendant, who's the plaintiff here, but D stands for defendant. He makes the unauthorized copies of a photo of Oscar Wilde. Very nice posed picture. I should have gotten one for you, but it's a nice enough photo for 1884. And he goes around selling them, and the guy who took the picture is also out there selling them. Oscar Wilde was a very popular guy at the time. And the defendant claims that the photo isn't original. You didn't do anything new. You didn't create anything. You simply made a mechanical reproduction of what's out there in the world. This is Oscar Wilde sitting on a chair. Oscar Wilde was, in fact, sitting on a chair right there. You didn't draw a picture of how you thought Oscar Wilde might sit on a chair. It was actually happening, and all you did was memorialize it through a sequence of mechanical steps. You didn't paint it as a life study. You didn't, do anything creative to the photograph. You didn't, I mean, back then I don't think there were as many techniques for sort of how to develop it and all the different things. There was certainly no Photoshop, right? So there is some weight to the argument that all you've done is make a mechanical reproduction of something that already existed. Where's the creativity in that? What have you done that's new and interesting? Why should we want to provide this incentive for creativity to you, the photographer? And the court back then said basically that in keeping with the sort of later opinions in Feist, that originality doesn't require that much, that you are allowed to get copyright protection for something that is minimally original, and in this case, perhaps even beyond minimally original, because you set the scene. The important part of the Serenity case is that it was a portrait taken with the intention of, sorry, Oscar Wilde was sitting there with the intention of this guy capturing his portrait. He posed the scene, he did the lighting, the creativity was in the sort of assembling the reality that he then made a mechanical reproduction of. And so that deserves copyright under their thinking and thinking today. I mean, that's still pretty much good law. Right? Nobody really disagrees with that point.
So if somebody makes it like identical, like somebody arranges Oscar Wilde and the setting in the exact same way, that's not, like that would be breaking the...
I mean, you might have a case for infringement, right? Because that's the creative work that we'd be protecting. It would be difficult just based on the mechanics of like maybe you're not taking a photograph of it, and so then you're infringing on the photograph by sort of restaging it. It's possible to do. I mean, it's not that copyright requires there to be any sort of identity of medium there. So I think there's definitely a case that you could make there. A lot of those cases come down to what we'll later see is the sort of fair use exception to the infringement. So yes, you copied it, but did you have a good reason, basically? We'll talk about that.
So there was a cover for an album in the 90s by Nirvana they had a baby like in a pool grabbing a dollar bill.
You guys are so young. Never mind.
Yeah. And then Weird Al Yankovic did something very similar.
Yes, he did.
Would
He got in trouble for that, I think.
he got in trouble?
I'm pretty sure he got in trouble for that. Weird Al Yankovic is a very interesting case because despite the fact that he would have an awesome case for fair use if he ever took it to court, he's just too nice a guy. He actually asked for permission. The only one I think he didn't ask for permission was Amish Paradise. Right. Coolio got snippy with Weird Al Yankovic because he didn't like being made fun of in that way. But by and large, this guy, who is the sort of, in some way, shape, or form, the preeminent parodist of our age, does not usually avail himself of the parody defense to copyright infringement. It's just not part of his business model, I guess.
What about the Obama photo, the Shepherd?
Yeah, Shepherd Ferry. Shepherd Ferry screwed the pooch on that one. So for those of you who haven't seen it, Shepherd Ferry basically made the famous Obama Hope and or change, I think it says one or the other, poster. He painted it from an AP photo that looks almost exactly identical. I mean, it's hard to imagine that he wasn't just sitting there with the photo and painting from it. And the question there is, is it copyright infringement, or is he making a fair use of the copyrighted image? And I'm actually going to table that until we get to fair use, because I think it's a very good case for it. But the actual outcome of the entire case is tainted by the fact that he basically sort of destroyed evidence on his computer after he found out the lawsuit was coming, which is a big no-no and which can sort of screw up the entire process of trying to get a clean ruling on whether or not there's copyright liability there. So anyway, let me get through the Bridgman case, which is a more modern case on photographs, but which gets to the very thin line where you might be making too mechanical a reproduction. So this is basically about paintings taken by, photos taken of paintings by museums and by other institutions that are basically engaged in preservation efforts. And so what they want to do is take a photo that looks as much like the original as possible, so that they can take that photo and use it for all of their purposes without having to expose the fragile old master painting to any of the elements or any of the people who might want to look at their catalog or look at their website. I mean, they have a lot of reasons to want to use the image without using the painting, basically. So the defendant in this case took those photos and sold a CD-ROM of them. They're like, these are public domain paintings. Nobody's disputing that. These are Rembrandts. I mean, any copyright term, which didn't even exist back then, but even under today's very long copyright terms, all of these things would be in the public domain. So the question is not, is there any underlying copyright in the paintings, but do you get a copyright independent of the paintings in the photos you take of it if all you're trying to do is reproduce that painting to the sort of best fidelity possible. And the court here said no. They said slavish copies do not have enough originality. All you're really trying to do there is show people what the painting looks like. You are not trying to add any originality to it yourself. But it is followed very narrowly. There are some cases where just not taking a good enough picture has been taken to sort of evince some other intent besides preservation and representation. And so it wasn't a slavish copy. They were just sort of, I don't know, you can imagine you go to a museum, you go to the Louvre, and you take a picture of the Mona Lisa. Well, I mean, you're not really doing it to have a slavish copy of the Mona Lisa. You can find that elsewhere. You're doing it to take a picture of the Mona Lisa. It may not be a good one, but in some ways, it's original. You've created an image of the Mona Lisa that doesn't exist otherwise. It's new. And that you would have a copyright in. So it is possible to sort of run afoul of the originality standard in photographs, but it is in this very narrow case where you're making that slavish copy of it. All right, so that brings us to the 1909 Act, which is the first modern copyright act that we have to care about because it's still relevant for some works published before 1978. So you'll see that there's a later 1976 Act that we still live under by and large, but the 1909 Act matters because copyright terms are long. And some things which were published before 1978 are still under copyright and still capable of being infringed upon. So the interesting features of the 1909 Act are that protection required publication and notice. So you did not get copyright in that stupid little napkin pen drawing the minute you made it. You had to publish it. And not only did you have to do that, you had to publish it with that ubiquitous little C notice with the date and your name so that somebody could ask you if they really wanted to republish it or if they wanted to make some use of it. And a lot of people have spoken very highly of this system in the sense that, yes, it did have negative consequences for people who didn't comply with these things, for people who published without notice, inadvertently, whatever that might mean. But it also forced you to sort of stand up and ask for copyright protection. And it gave us, because it was publication and notice, a good heuristic for figuring out whether something was copyrighted and whether we could use it. If I found a published copy of your manuscript without any notice on it, good for me. I get to use it. One of the most famous cases of this is the movie Night of the Living Dead, which was apparently published and produced out into the world without the proper copyright notice. And so despite the fact that it's not generally old enough to be assuredly in the public domain, that one thing is, because they published without notice. There are other instances of that, but that's sort of perhaps the most famous and most popular. Back then, the term lasted for 28 years, renewable for another 28, so a total of 56 years. And it's notable also for introducing compulsory licenses, which are all over the Copyright Act now, but which before hadn't really been thought of. And a compulsory license is simply a license that you don't get to say no to. You, the copyright holder, make a work, and somebody is allowed to do whatever the compulsory license says, but they have to pay you a fee. It's usually set by, it's called the Copyright Royalty Board. Sometimes it's in the statute. There are different ways it can be structured, but the point is that it's compulsory. I don't just get to say no license. And this was originally put in here for piano rolls, but now you probably know it as the reason why it's enormously cheaper and easier to cover a song than to sample it. This is a sort of interesting dichotomy that's come up as we have these different ways of using previous musical works. There is a compulsory license for doing cover songs. You can record anybody else's musical composition for a certain flat rate, and they can't say no. You don't have to ask for their permission. You just owe them so many pennies per copy, and that's it. That's why, you know, every album, you know, can have covers on it.
How did Lou Reed stop Susan Boyle from singing that song on?
I couldn't tell you. sorry, I'm not familiar with that particular case, but I can only imagine that there were, well, there's other ways to exert pressure, but there also may be other ways to keep someone from doing it in the way in which they want to do. So to be clear, I'm talking about the right to fix a musical recording of that musical composition. I'm not talking, maybe that's where we're getting, where you got crossed up. I'm not talking about the right to perform it publicly. That's a different right, and so it may have a different licensing associated with it. But I don't want to talk too much about a case I don't know anything about.
So what are the implications of the Night of the Living Dead example? Does that mean anybody can become their own Night of the Living Dead publisher and sell copies of it for a certain amount? Okay.
Yeah, pretty much. I mean, copyright is the tool that you would use to keep people from making copies. And so if there's no copyright protection, you can make those copies. You can do mostly what you will with it. I mean, the point of things being in the public domain is that you don't have to ask permission for anything, really. There are other, I mean, like we saw, maybe you run afoul of trademark law. There's an interesting Supreme Court case about the intersection there. But under copyright law, you won't be liable for copyright infringement no matter what you do with the work that's in the public domain. That's sort of the definition. So anyway, we have the 1909 Act, and then in 1976, after 15 years of hearings and committees and all sorts of shenanigans on Capitol Hill, we get the 1976 Act, which has been amended since then many times, but is still the bulk of it is today's copyright law. It's in the Consolidated U.S. Code under Title 17. Starts with Section 101, which is definitions. There's a lot of definitions. Almost every term is defined. Some terms are defined, and then the terms used to define that term are then themselves defined. It's a long section, and worth reading only if you're really interested in this stuff. Section 102 covers the subject matter of copyright. And so you can see here all the different kinds of works that are covered by copyright. And while we tend to say that any sort of original work of authorship is covered, it needs to break these out into all of these different subcategories because there are all of these sort of compulsory licenses and exceptions and other parts of the statute that may only apply to one of these. So before we were talking about cover songs, that's only applying to musical works. That's not applying to, I can't cover a sculpture or something like that. And it's explicit in Section 102 that copyright does not cover ideas, procedures, processes, systems, methods of operation, concepts, principles, or discovery. You'll find very similar language in the Patent Act saying this is what we do cover. And that's basically what they're doing there is splitting off patentable subject matter from copyrightable subject matter and trying to make sure that we cover what we mean to cover with each kind of law. Section 105 is, not long, but interesting to note that there's no copyright in works made by the federal government. If you're a federal employee making something under terms of your employment, scope of your employment, that's it.
So what about things in the Library of Congress?
Yes, the important distinction there is that the federal government is allowed to hold copyrights. So if the copyright came from somewhere else, you are allowed to transfer it to the government. Similarly, state governments are allowed to hold copyrights if they want. They're allowed to get them for their own work, although often frowned upon and really not of much use, I think, in most cases. But no, the Library of Congress, and I guess that's an important point that we should make, is that libraries and other owners of physical products don't own the copyright. So the copyright in the work is distinct from the the property right in the individual sort of printing of the work that you have. So the library is entitled to own its books. It's not entitled to own any of the works that those books sort of embody. And then, like I said, lots of limitations and exceptions, which comprise basically the rest of the Copyright Act, including Section 116, negotiated licenses for public performances by means of coin-operated phonorecord players. So yeah, there's a whole statute for jukeboxes. And notice how, most of the jukeboxes we have today might not meet that statutory definition. So it is, probably phonorecord we could be a little more liberal with, but the fact is there's a lot of detailed exceptions. There are lots of them regarding cable retransmission and other things. I'm not going to get into those. I can't even tell you that I get into them in my semester-long course. If you want to know about these things, you actually do just have to go read the statute and try to make sense of them like the rest of us. So the important parts of the 1976 Act are basically duration, infringement, and fair use, in the sense that first thing you want to know is something in the public domain? Do I have to worry about copyright at all? This is a complicated question, unfortunately, because terms have been changed over the life of these works, and terms have been later extended. And so generally, you get the term that was existing in the copyright law when you made the work. But if it's later extended or later altered, you end up with basically a big long chart of conditions that you have to meet, and then it tells you what term you're actually going to get. I put the link at the bottom of the slide here. I'm happy to email it out to the class if you're curious. But that's really the best chart I've found for trying to make sense of it, and you really do just have to jump through the hoops when you find a specific work you want to use. That said, here are some basic guidelines. Things published before 1923 are in the public domain. And I mean, that's just true. That's the one sort of hard line you can draw. And that's fun to some extent. There's some good work from back then. But it gives you a sense for how limiting it can be, in the sense that if you really want to be sure that what you're using and what you're copying is not subject to copyright, you have to go back past 1923. Everything since then might still be covered. For works published, most works published before 1978, because there are exceptions, especially around, like we saw with Night of the Living Dead, did you comply with the relevant formalities at the time? But for most works before 1978, if you published with notice and it wasn't expired in 1978 when they changed the law, you got 95 years from publication. It's a pretty long time, but you know, things will start going back into the public domain in a few years. We've had a sort of pause here since the Sonny Bono Copyright Term Extension Act in 1998, where things just aren't really going into the public domain. We haven't had anything new in a while. For most works published after 1977, and these dates are different just because the effective date of the 1976 Act is January 1st, 1978. So anything published after 1977 is life of the author plus 70 years, or if no real author, meaning if it's a corporate work, work made for hire, or an anonymous work, you get the shorter of 95 years from publication or 120 years from creation. Basically trying to cover, you know, unpublished works that get unearthed decades later and give them some kind of reasonable approximation of the publication term that other works would get. So that's duration, for better or for worse, right now. Infringement is the whole ballgame, in the sense that what are you worried about, right? You want to know, if you use a copyrighted work, when would you be liable and what would happen to you if you were? Section 106 of the Copyright Act says that the copyright holder has the exclusive right to reproduce, prepare derivatives, distribute copies, or perform or display publicly the copyrighted work. So it's most things. Each one of those is a separate right, and so you can infringe all of them, you can infringe just one of them. There's a lot of ways to be violating, to be infringing a copyright. And Section 501 says that any violation of a 106 right is copyright infringement. And this is important because it means it's a strict liability standard. And this is not that common in the law. There are not that many legal doctrines that make you liable for something without any investigation into your intent, what you were trying to do, your motivations. There are lots of, crimes require that you have some sort of guilty mind, it's called, mens rea. Most torts, most sort of injuries that you might have to compensate someone for require you to have at least meant to do some part of the action and require you to have been negligent in, leaving your baby by lead paint or something like that. But copyright just says you violated it, you infringe. If you infringe, that's it. You basically are guilty in that sense because you violated one of the 106 rights. And here, as we mentioned, copying is determined by substantial similarity, so it's more nuanced than just, is it exactly the same thing? Did I actually just sort of burn a copy of the exact same CD, or did I, make a mix CD, or did I even, make a remix of the particular song? All of those would still be covered by the rubric of substantial similarity, which is a two-part inquiry. Not going to go into it here, but just know that it's not just copying. It's anything that's sort of substantially similar. Question?
So infringement covers reproduction and distribution of copies. So what about reproduction for my own use, or just obtaining a copy that's been distributed to people?
No, you don't. You're not guilty for possessing.
Okay.
You're okay. But that one copy you made for your own use, definitely, that's an infringement. It's not the case that it has to be done for money. I've heard that a bunch of times. I have a couple of friends who are musicians and who, despite my best advice, decided that it's okay to put out a mixtape using samples from other people's music that you didn't clear, as long as you don't sell it. And I guess in some case you could say that, okay, well, that means that there's no damages, because I didn't make any money off of it. But that's really not true, as we'll see in this next point. You are allowed to, as potential remedies, get an injunction, get seizure of the goods, or damages. An injunction meaning that you get a court order to stop doing the infringing activity, or somebody goes to jail. And not for infringement, but for violating an injunction. It's contempt of court. You basically have to comply with an injunction. There are very, very few ways to avoid that.
So you can argue that downloading is copying, because you're taking a file that's somewhere and you're creating another copy of it on your own computer.
Sure.
Is it considered reproduction?
Sure. Yeah, no, absolutely.
So the act of downloading is illegal, but...
Right. And maybe you're getting at the idea that mostly when the RIAA has been filing lawsuits about peer-to-peer file sharing, they've been filing them on the basis of uploading. And I agree that uploading is a better case in the sense that you are in no way licensed. I mean, we can assume, basically, the RIAA is assuming that you're not licensed to distribute their work. Because, sure, they give you a license to possess it. You bought the CD from them. And so I think the idea is that if you came into court and you said, but Judge, I own the CD, so I downloaded it. Well, I didn't really understand that was like an infringing copy versus the copy that I already own. I thought I paid them for the song. None of that is actually sort of good copyright argumentation. But it's much more sympathetic than going in there and saying, oh yeah, I let somebody else download that song off my computer. There's no way in which the record company, allowed you to do that. You're not given a license for that.
But every time, you download something or even just look at something, you're making copies and making copies.
Yeah, there's definitely a tight question around the sort of intermittent copies. There have been some cases to say, okay, we're not going to hold you liable for the copy from the hard disk into RAM or something like that. Like there are instances where that's been said to be sort of too incidental and not really involving the human operator at all, so that we won't hold you liable for that. But most of the copies you can sort of manually make on your computer would be considered infringing copies if you weren't licensed to do it. All right, I'm running out of time, so let me blow through some of this. Criminal infringement is worth noting just because you could actually go to jail for this stuff. There are some extra provisions that keep you from going to jail for run-of-the-mill copyright infringement, but it's worth noting that there's a pretty strong sort of anti-camming provision in there that is very tightly crafted around the requirements of you cannot videotape a movie that's only in the movie theaters and put it up on a torrent site. That's basically what the law was written for, and it does a pretty good job of saying you can't do that. So nobody's actually been prosecuted under that statute and sent to jail for doing what I just said, but it is definitely something that the Justice Department could decide they want to start doing any day of the week. Secondary infringement is where a lot of the action is today because it's about someone else being liable for your infringement. This is what brought down Napster, Grokster, et al. This is where companies get sued because, nobody at Napster was maybe somebody at Napster was going out there and downloading files for their own use on the company time and on the company servers. But what they really cared about is the fact that Napster was enabling all these other people to go out and infringe copyrights. And while Napster's the most recent example, this started with the famous case of Sony versus Universal, which was about the original Betamax recorder, which is the first case where we have fair use explored around this kind of infringement. But that's on the next slide. And what's really important to know about secondary infringement is that there are a bunch of different ways to get into it, but that it's not different, in a sense, from regular infringement. You will be liable just as if you were the direct infringer. And so that's why you hear about, Viacom suing Google for, billions of dollars. Because if they're secondarily liable, it doesn't change their liability at all. They are liable for each of those infringements that those people have made by uploading videos to YouTube and such like that. All right, so fair use. We need to at least get through that. Section 107 says that some uses that would otherwise be infringing will not be, based on these 4 factors. The purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use upon the potential market for the work. We can talk about the middle 2, but the real important ones are the first and the fourth.
So actually, our time is up, so I think I'll just ask Fred to start with fair use.
Fred will start with fair use. Okay.
Thank you so much.
All right, thank you guys.